Hi everyone, this is Pratyusha for G2G News. In this episode of Gaming Byte, I will take you through the background of the much anticipated decision of the Karnataka High Court in the batch of petitions challenging the Karnataka online gaming ban law that is expected any. In the last hearing a few days before Christmas, the parties have concluded the arguments and the bench directed the parties to provide with written submissions if they wish to do so. Karnataka is a crucial state for gaming operators, not just because it is the Silicon Valley of India, but the state is amongst the top 10 states in terms of having educated working class who are well versed with digital space, including online skill games. Now, coming to the case before the High Court, we have around 12 petitions challenging the enactment and one implead petition supporting the government. The petitioners, including gaming self-regulatory body AIGF, Unicorn Gaming Platform MPL, Jungli Rummy, Games 24/7, Gamescraft, Head Digital Works, the parent company of ACE23, the Fantasy Sports Self-Regulator FIFS. A battery of senior counsels appeared for petitioners, which includes Mukul Rohtagi, Arvind Datar, C.A. Sundaram, Dr. Abhishek Manu Singhvi, D.L.N. Rao, and Sajan Puvaya. The government was represented by the Advocate General Prabhuling Navdagi. The case was initially heard by a single bench of Justice Krishna S. Dikshit and was later transferred to a division comprising of the Chief Justice and the Justice Krishna S. Dikshit. The matter was initially heard only for interim relief, which again was converted to final arguments based on confirmation of all the parties involved. The arguments by petitioners were primarily centered around the law being disproportionate, paternalistic in nature, and the state lacking power under the Constitution to impose such a blanket ban. During the hearing, the Advocate General appearing for state government has taken the stand that the amendments do not ban online games of chance or games of skill. They only restrain people from risking money on the happening of an uncertain event, and online platforms are prohibited from inducing gullible public with the lure of unattainable prizes. The AG cited the example of the game of cricket which continues to be played in the state. The AG also cited public order under which the state can legislate the law. The AG further said that the games of skill which were advertised at large would lose the skill of component as all the players are skilled enough. The AG further said games of skill when advertised at large would lose the skill component as all the players are skilled enough. Dr. Singhvi contended that a fundamental right to trade and profession under Article 19(1)(g) would require something extraordinary to completely extinguish it. He said that for public order, one must demonstrate on the affidavit public disorder. The petitioners relied on the recent judgment of the Madras and Kerala High Court and also decades-old cases like RMB Chamar Bagwala, State of Andhra Pradesh versus Satyanarayana. The Advocate General appearing for the government tried to differentiate between the earlier decisions and the present facts. The AG argued that games of skill would lose their nature when the public at large is invited. To the unaware, in August, the Madras High Court, in a landmark decision, struck down a similar law enacted by the Tamil Nadu government. The Madras High Court held that skill games are protected under Article 19(1)(g) of the Constitution, and any restriction must be reasonable. The decision is presently challenged before the Supreme Court by the Tamil Nadu government. The decision by the Karnataka High Court may be delivered any time soon. Whosoever loses are expected to approach the Supreme Court, joining the Tamil Nadu government. In the end, the much needed clarity on the skill games is expected once the matter is adjudicated by the Supreme Court. Currently, we also have similar petitions before the Telangana High Court and the Andhra Pradesh High Court challenging similar laws enacted by the respective states. We will keep you posted, and until then, bye. Follow us on Twitter, Facebook, and LinkedIn for instant updates on gaming regulatory developments. Thank you.